Good morning and welcome, everybody. I'm Harry Miller, and this is the Herzog Law Firm's annual client appreciation event. Thank you all for taking the time to join us this morning to talk to you. We am here today with the partners in the firm, Debbie Verney, David Kabikian, and Jane Marie Schaefer. Also with us today is our certified care manager, Kim Hance, and we will be giving you a presentation over the next hour or so to hopefully enlighten you, hopefully also entertain you to some extent, and maybe even be a short trip down memory lane for some of you. So this is always, I think this probably is the firm's most important presentation and most fun presentation we do every year. And it's because it's our opportunity to thank all of you who are our clients and who have entrusted your estate plans and your family plans with us all these many years. We really appreciate your confidence in the firm and your continued understanding and faith in our ability to deliver high quality legal services to you and your family throughout the estate planning and life process. It's also a really special year for this law firm because whether or not you know it, this year, 2021, is the 75th anniversary of the Herzog Law Firm's founding. Yes, we were founded back in 1946 when Jake Herzog came back from World War II. He was a military officer in the Army during the war. Jake was stationed in Saipan, which is one of the Pacific Islands, off the coast of the Philippines and Japan, and was actually working in the Army on a proposed land invasion. The government was designing a type of land invasion. And then, of course, the war ended differently. And he came home. He was a lieutenant colonel in the Army. He came back. He stayed in the military. He stayed in the New York State National Guard and actually retired as a brigadier general in the 1960s. He also served as a city court judge in Albany. He was city treasurer. He was an unsuccessful candidate for Congress back in the 1960s. A really fine gentleman who founded this firm and instilled all of us with his own values of delivering excellent, high-quality legal services to our clients for reasonable fees and in an effective, time-effective manner. He was a people person. He met one-on-one with people, and we are a client-oriented firm. We really believe in interactive contact with our clients, whether in-person conversations or, as we've had to do for much of the last year and a half, Zoom conferences and telephone conferences. But when you come into the office and you meet with one of the attorneys, you're going to actually meet with one of the attorneys, not a secretary, not a paralegal. And we really pride ourselves in being a client-friendly, people-oriented law firm. So at this point, we've put together a short little video to take you back on a little trip of nostalgia back to 1946. Now, in order to remember anything about 1946, unfortunately, you have to be more than 75 years old. So there may be a few of you out there who actually remember 1946. For the rest of you, well, it'll be a little history lesson about what life was like in 1946. So sit back, relax, and watch this little video we put together for you. So there you are. A little trip down memory lane for some of you. You know, in 1946, we were talking about, David and I were talking about this earlier, the average life expectancy in 1946 was about 65 years old. For men, it was a little more for women. And you know what the average Social Security check was in those days? About $25 a month. Today, when life expectancy is about 82 or 83, average Social Security checks $1,500 a month. So we've got a long way from that. A couple of other important events that happened in 1946, just for your information and enjoyment. United Nations held its first meeting following World War II in 1946, and UNICEF, the United Nations International Children's Fund, was initiated back then. In the fashion world, guess what was introduced in 1946? The bikini. The two-piece bathing suit right after World War II. Interestingly enough, I read this. It was actually named the bikini for the Bikini Atoll in the South Pacific, which is one of the islands where the atomic bomb was tested before it was used in World War II. What a bizarre way to come up with a fashion icon. Anyway, as we said, gas was 15 cents a gallon. An average car cost about $1,100, and you could buy a nice brand new house for $5,600. So it's just absolutely hilarious the way we've come along. So sit back, relax. I'm now going to introduce our first presenter, who is Kim Hance, our certified care manager. She's our client services, care services manager. And Kim is going to fill you in and give you an update on the community Medicaid program that provides home care for folks. Thank you very much.
I think we're good now. Sorry about that. A little technical difficulty. So as Harry said, that was quite an interesting tour down memory lane for the, where we've come from and where we are now. As Harry said, my name is Kim Hance. I've had the pleasure of meeting a lot of folks that are here with us today. But for those of you who I've not met, I am a certified care manager, geriatric care manager, aging life care manager, lots of names. But at the end of the day, I'm a social worker and I specialize in aging issues. So what I do for the firm is I work with our clients to help navigate through all of the long-term care services, resources, community resources that are out there to help with folks in maintaining as much independence as possible, because obviously as we age, things aren't as easy as they once were. So we are really here to be a full service firm for you and to really help you all with your aging plans and your goals. So I'm going to talk about the community Medicaid update because there are a lot of changes that are going to be forthcoming. We talk a lot in our webinars about community Medicaid aging in place. And so many of you are familiar with the Medicaid program. There are two different kinds of Medicaid. There are chronic care Medicaid, which is for nursing home, which most people don't want. And then there's community Medicaid. And community Medicaid is for providing services in the community. So it could be in your home, it could be in an apartment. If you have chosen at some point to maybe downsize into a senior living community or a independent living community. It's perhaps bringing services into that community to you. It can cover not just home care, but adult day programs. There are a handful of assisted livings in our area that will accept community Medicaid as well. So it's a program that allows more flexibility and freedom to develop an aging in place plan. So currently under community Medicaid, there's no look back. So basically what that means is you can apply for Medicaid. We can do some planning if you're overqualified from an income standpoint. We can do some planning to get you qualified. And currently, it doesn't matter if you have $1 million in the bank, we can transfer that out, protect it, and apply for you the following month. That is going to be changing come January. So New York State instituted a look back starting October of 2020. However, we were in a pandemic and we were under a state of emergency law. So at that point, it delayed our look back period. So starting in January, there will be a look back starting in October. So if you're going to apply for community Medicaid after January 1st of 2022, they're going to look at all of your financial transactions to October 1st of 2020. If you apply for community Medicaid between now and January, there will not be a look back. So you still have a little bit of a grace period between now and January 1st. So if there's anyone out there that thinking about needs services, it's one of those things that you should probably do sooner rather than later, because we have a few months left ticking on the clock to be able to apply. So with the delay of the rule, it will go back to October of 2021. Really, there were no changes instituted to Medicaid during the pandemic. And, again, as we were talking about, everything will start in January of this year. So some of the good news first is that the look back will only apply to what we call managed long-term. So under Medicaid, you can access two different kinds of care programs. One is the nursing home transition diversion waiver program, or the traumatic brain injury program. It's a program we utilize a lot for our clients. And then there's the managed long-term care program, and under which that you can also access consumer-directed personal assistance program. So under the NHTD program, there will continue not to be a look back. So that will be one of the ways that we can access and help create a good long-term care plan for you, utilizing some of these different programs. And obviously, if we need to do some planning, we will try to help coordinate some of the other services that sort of blanket around some of the Medicaid programs that we use as well. As we know, planning early is so important. We all have heard the saying, an ounce of prevention is worth a pound of cure. So now more than ever, you need to get your planning done. If you've been sitting on the fence and you haven't really, you've been thinking, well, maybe I should do this, and I'm not really sure if I do it, now is the time. Because, again, starting January 1st, they're going to be, the look back is going to be 30 months. So they'll start from January, look back to October, which of course is not 30 months. But then with each month as they move forward through 2022 up until the 30-month mark, they will be looking back at all of, again, your financial transactions. And again, just to reiterate that, under nursing home, there is a 5-year look back. So lots to think about and consider when you're doing your planning. Some of the other changes that are happening and that have been delayed to 2022, in order to be eligible for services now, you only need assistance with 2 of the activities of daily living. And for those of us who regularly watch our webinars, the activities of daily living are things like bathing and dressing, toileting, ambulating, transferring, And so currently, under the current rules, you really only need to have hands-on assistance with 2 of those activities of daily living. So that's going to be changing to 3 activities of daily living. And if you currently have a cognitive impairment, you only need to have assistance with 1 of those activities of daily living. That will also be changing in January to where you will need hands-on assistance with two of the activities of daily living. So they're making it a little harder to physically qualify as well. So from a financial standpoint and now from the medical standpoint as well, things are going to get a little more challenging. There will be a new task-based assessment that will be done. And unfortunately, it's going to be done by someone who doesn't know you. Currently, we can qualify people under medical reports from your current physicians, the physicians that see you and know you. Unfortunately, come with the new rules, you'll see an independent doctor that will really have no idea of what your actual needs are and really don't know you. So those are some things that are concerning to us because you know, it's much more helpful to have somebody who knows you and understands what your needs are to be able to help explain how you would utilize this program. So some of the other updates that we need to think about and you need to know about, with the end of the state of emergency, our facilities are starting to open up again, which is so wonderful for families and for the residents in the nursing homes. Most facilities right now are not requiring sign-in times or special times to visit. There are still some facilities where you have to sign up or there are special visiting hours. So what we're advising folks is just to make sure that if you have a loved one that's either in an assisted living or nursing home, just check with them to see what the visiting hours are. But it's wonderful now that we can visit folks again. Our adult daycares are starting to open. They've been virtual for the last 1.5 years, and they are starting to open. The challenging part of that is some of our adult day programs permanently closed during the pandemic. So some of the day programs that are currently opening have long wait lists. So yet another reason to start your planning early so that you understand what the options are. We do access a lot of the community resource programs, things like the Eddie Alzheimer's respite program. There's the Caregiver Support Initiative up north that we utilize to help families sort of get through challenging times. Catholic Charities offers some respite time as well. So we're always looking you know, for avenues to help our clients, even if Medicaid's not going to be the most accessible or immediate answer for folks. So, you know, again, we are trying to work with our clients and help you solve as many problems as possible in a very holistic, rounded way. So next, we're going to have Debbie Verney. She's going to talk about the new power of attorney and the changes that have happened to the power of attorney document.
Good morning, everybody. It's great to be here. We get to talk to you via Zoom. Hopefully we'll be in person, right? We were just talking about that before this started, about how we miss seeing your lovely faces. We miss seeing you. We really want to get out there and see you again. So without further ado, we're going to talk about the new power of attorney. This has been a huge nail biter. People have been waiting for this to happen for a long time. Everybody comes in and goes, hey, how can this be the short form if it's 13 pages long? Well, guess what? The governor signed it into law in December of last year. And as of June 13th, we have a new power of attorney form. Exciting. I can tell you're all clapping. So what happened? Our form went from 13 pages to 10 pages. So we saved you a whole 3 pages. They eliminated the statutory gifts writer. There's new different signing requirements. You know, you can read the slide. It's all exciting stuff. The most exciting part is that the banks have signed on to this, and there's going to be a lot better acceptance of powers of attorney as long as they were executed properly. So let's go through a few of the changes. So signing requirements. A lot of you probably didn't know that you can actually sign a power of attorney on behalf of a person. So what does that mean? So if you have a person who's unable to sign for themselves, So say there's a person in the hospital that is paralyzed and can't sign for themselves. A person can actually sign on their behalf. So the person that signs on their behalf cannot be a person that they've appointed, okay? They can't be a witness, and they can't be a person that was actually appointed as an agent in the document. So you obviously need a disinterested witness to be the witness, but they can sign and date on behalf of the principal. So what else? So what about two agents acting together? This was something that was in the old powers of attorney. Whenever you were naming people, whether you wanted your kids to both act together or either or could act, or you had each other first, the question is, how are they going to act? Well, now, if you have a co-agent, right, they can assign their responsibility to the other agent. So if you have a situation where someone's out of state or out of the country and they can't sign, they can actually assign their ability to sign to the other person that's appointed, right? Remember whenever you signed your power of attorney with the statutory gifts rider, and we told you the reason you had to do the statutory gifts rider was because there was a limitation on gifting at 500? Well, now they've raised it to 5,000. So without the modifications now, again, no statutory gifts rider, the most a person can gift is $5,000. And a lot of you are thinking, well, why would I care if someone could give $5,000 or not? That seems like a lot of money. Well, if you had a situation, which I did in the past with a husband and a wife, the husband goes into the nursing home, he's not able to sign anything, right? So how are we going to get the house transferred out of his name? Because the house is obviously worth more than $5,000. So these are just things to think about going down the road. And also, a power of attorney cannot make healthcare decisions for you, right? We're kind of reiterating that because in the new power of attorney, there's a specific paragraph that says that your power of attorney cannot make healthcare decisions for you. And obviously your healthcare person can't make power of attorney decisions for you. So healthcare is healthcare, power of attorney is financial, but your power of attorney can contact the insurance company and say, hey, is this covered? Do we need a second opinion? I need copies of the medical records. These are all things that they can do, but your healthcare proxy is going to make your healthcare decisions. So this is the biggie, right? That they're trying to make sure that the banks and financial organizations are going to accept your power of attorney. So they say that nobody in New York can refuse it if it was done correctly. So you present it, they have 10 days to either honor it or reject it. So let's just say they reject it. There's no specific time that you have to respond, but after you respond, they have 7 days to finally accept it or reject it. This is great because, again, they've had the financial institutions, the banking institutions have all signed on to this, and they've said, hey, if this is a valid power of attorney, then we're going to accept it. So what are they going to do, right? They're going to have a checklist. So the banks and the financial institutions are now going to have a checklist that says, you know, was it signed? Was it dated? Does it have all these powers? And if it fits their criteria, then they're going to accept it. So what our hope is, and the hopes of banks and the Bar Association, is that now that there's the standard form and that there's this language, that the financial institutions are actually going to accept the power of attorney. There's not going to be any issues and everything will be great and fun, right? So think about it. It's enforceable if it was executed correctly. So what does that mean? It means that you really should have an attorney do your power of attorney. I have seen a lot of forms that were downloaded. I've seen a lot of forms that were downloaded incorrectly. I had a couple, a daughter and a son that brought in mom's power of attorney that he downloaded from one of the legal websites, and he brought it in. He's like, it's fine, right? I'm like, yeah, no, not good. So we ended up going to the house and doing a new power of attorney. You really need to watch it because the banks don't have to honor it if it's not valid, right? If it's not executed correctly. And now they're going to have a checklist. So they're going to be able to tell you, yeah, no, you downloaded this from the internet. This is not valid. You know, sorry. And if the person can't execute a new one, then you're kind of stuck. And then you have to do a guardianship proceeding, which we know you don't want to do. So are the old powers of attorney grandfathered? Yes, they are. But the language is if they were executed properly during the time that was valid, right? So if you executed a power of attorney prior to June and it was on the correct form and you did it correctly, then they're going to take it. but you need to start thinking about, have there been any changes, right? So look at your power of attorney, pull it out. Who are your agents? Can your agents still act? Are your agents alive? A lot of times we have a situation with, on the powers of attorney, husband and wife appoint each other, then they appoint the kids as backup. So the question is, right, is your spouse still alive? Can your spouse act for you? A lot of spouses are the same age, right? So the problem with that is you're both aging in place, right, at the same rate. And one of you may have a cognitive impairment and you're not able to make those decisions anymore. So what do we need to do? Do we need to redo the power of attorney and move the kids up? Do we need to have the spouse resign as power of attorney so the kids move up? If you haven't dusted off your power of attorney in a long time, you really should look at it to make sure that it is valid, to make sure that the person you've appointed can act. Because if you don't have someone on there that can actually act, the power of attorney isn't worth the paper it's written on. So you really need to think about these things. Make sure that you have a valid document, and we would be happy to review your document. And if you want the newest, latest, and greatest, we'd be willing to redo your power of attorney for you. So I'm going to now introduce Jane Marie Schaefer, and she is going to talk to you about President Biden's tax plan.
Hi, everyone. So I get to talk about taxes, the most exciting part of the presentation. There will be a lot of numbers here, so I apologize in advance. But it's just good to know what the tax proposals are. They may or may not apply to you, but we like to keep you well informed on what's going on in the world of taxes. So here are some of the proposed tax changes. I'll talk about the increases first, and then I'll talk about some of the good news, credits and decreased tax rates. So of course, one of the main components of the tax plan is to raise taxes on corporations. As you know, this is very unpopular, not likely to get passed, but this is the proposal. The proposal is to increase the top corporate tax rate from 21 to 28%, and also to impose a minimum tax rate of 21%. So the minimum tax rate would eliminate, the possibility of a lot of these corporations, not paying any taxes because of tax shelters or deductions or things like that. So this is going to be, of course, an unpopular provision. Corporations are saying if they have to pay taxes, that's going to have to be passed on to the consumers. They're not going to absorb the cost themselves. Along with the proposed corporate tax changes, there are proposed changes to the individual tax rates. Now, most of us don't have to worry. It's aimed towards the very wealthy. So what they're proposing is to increase the top income tax rate from 37% to 39.6%. Now, this is what it was, 4 years ago, before it got changed. So it's not unusual to have the top tax rate this high. This is what they're proposing, having it go back to. The other proposal is to change the capital gains tax rate on those earning over 1 million. Capital gains are if you sell stocks or mutual funds and you have a gain. Currently, you pay capital gains tax rate at about 20%. This would make, for those high earners, the capital gains tax rate 39.6%. So again, taxes on the very upper echelon, high earners, isn't going to affect the majority of people. These are some changes that are credits, which are probably going to affect, a lot of people. May not affect some of you on the call, may affect your children because it's child tax credits. So they're going to extend the child tax credit through 2025. They're going to have a child tax credit of $3,000 per child for children who are ages 6 to 17, and $3,600 per child who are under the age of 6. And that what they're doing, and you may have heard, is they're starting to give out checks, monthly checks to individuals. So if you have a child, you'll get a check, maybe $300 or more, depending on how many children you have. So that's going to provide some much needed relief to families. Another thing that's going to help families is to make the child independent tax credit permanent. This is the credit where you can deduct your childcare expenses. And many people need to have, daycare for their children so they can work. So you get a little tax credit on paying for daycare. You can deduct 50% of your childcare expenses, but there's a max $4,000 for one child and $8,000 for 2 or more children. I know daycare costs much more than $4,000 a year. I went through that not too long ago, but at least it's something, it's a start. Another benefit is that the earned income tax credit is going to be made available to more people. It's going to be increased for workers without children, and they're going to expand the credit to workers over age 65. And this is something we see a lot more people over 65 working. In fact, our first speaker is still working, Harry Miller. Believe it or not, he is over 65 and he's still working. So along with many other workers who do have to work, that is an available credit to them if they meet the income guidelines. Now, these are the proposed estate tax changes. Now, before I go through these, I will have to say the estate tax really affects less than 0.1% of the population. And even with these new changes, it's still not going to affect that many more people. But what it is it's going to increase the amount of taxes that those individuals do have to pay. They're going to keep the current exemption of $11.7 million per person. So if you have less than 11.7 million or less than 22 million, if you're a couple, you do not have to worry about estate taxes. Now, what you may have heard in the news is that they are going to eliminate the step up in basis. And there's a lot of talk about that, how that's a very bad thing. And it is, a bad thing for taxes. But as you'll see, it doesn't really apply to a lot of individuals. So the step up in basis, if you have something like stocks or mutual funds that increase in value over time, when you sell them, you have to pay capital gains tax. Now, there's one benefit is that when you die and it passes on to your children, they get to reset the basis. So if you bought ExxonMobil stock, for example, I don't know, 30 years ago, and it was $5 a share, and I'm just making up random numbers here. And then when you die, it was $50 per share. Your children don't have to pay the tax on that increase in value under current law. Under this new, under this new law, when you die, they would have to pay the tax on that increase in value. And that's in addition to the estate tax. So you could be faced with 2 taxes. Now, the good news is they have a $1 million exemption. So the first $1 million of unrealized capital gains are going to be exempt. So it's, again, not going to affect a lot of people. Not many people have stocks that have increased more than $1 million. There may be some who have. It's $2 million for a couple. The primary residence is going to be exempt. There's currently an exemption when you sell your house, that the first $250,000 of capital gains is exempt, or $500,000 if you're a couple. So that's going to apply also in this situation on death. And if you have a family business, they realize that it's difficult for a family business to pay taxes because they're generally not liquid. So what they're doing is there's a deferral of the tax on your family business. So you would still have to pay the tax, but you could pay it over time. So again, the very wealthy are going to have taxes on both unrealized gains, and they're going to have an estate tax. But just be aware of that $1 million level, because that's more likely that some people may reach that level than the $11.7 million of estate tax exemption. Now I'm going to talk a little bit about the New York state tax changes. So again, New York State had changes this year where they increased the taxes on the very wealthy, but they did reduce taxes on the middle class. So again, they changed, or they increased, I should say, the highest corporate tax rate. That went from 6.5 to 7.25%. They increased the highest individual income tax rate from 8.8% to 9.65%. And they added 2 new high income tax brackets. If your income's over 5 million, you have to pay 10.3% tax. And if your income's over 25 million, you have to pay 10.9% tax. So, you know, the fear is that, you know, New York is a very unattractive state to live in, and that's going to drive a lot of people out of the state because of these high taxes. You know, a lot of people move to Florida or other states that don't have any income tax, you know, to try and decrease their taxes. Now, some of the decreases for middle income taxpayers is good. They're slowly lowering the tax rates for middle income taxpayers. You know, if your income is between 27,000 and 161,000, the rate will decrease from 5.85 down to 5.5%. And if your income's over 161,000, but under 323,000, the rate will decrease from 6.25 to 6%. And that's good news because, you know, New York has one of the highest tax rates in the country. So they are trying to bring that more in line with other states. Now, New York estate taxes. The New York estate tax exemption remains at $5.9 million. So over $11 million if you're a couple. So again, that does not affect the majority of individuals. But I did want to highlight one thing to go over. If your estate is around that, you know, $6 million level, there's something that you should be aware of, and that's called the New York estate tax cliff. And it's a strange way that the law works in New York State. So if your estate is around, you know, that cliff, around that 5.9 million number, up to 105% of that number, you get to use the full exemption. However, if your estate is more than 105% of that $5.9 million exemption, you are taxed on the full amount of your estate. You don't get to use that exemption. So here's an example, you know, and I know numbers are tough, but just briefly, if your estate was 6.1 million, you would get full use of that exemption, right? And you would only be taxed on $237,000. That's the difference. However, if your estate, if it only went up a little bit, you know, and it got you above that 5% mark, it's 6.2 million. Then that entire 6.2 million is going to be taxed. You don't get to use that $5.9 million exemption. So for individuals who are around that mark, you want to really pay close attention to your estate and try and bring it within that limit, right? Bring it below that 105%, because that does make a huge difference in tax. So I hope I bored you all with these numbers. We're going to bring in the relief over here. David Kubikian is going to talk about real estate and trust. Here you go.
Thanks, Jay Marie, and welcome everyone again. As you can see from everything that Debbie presented on, and Kim and Jay Marie, our field changes quite frequently, and it's always a good idea to stay up to speed, whether it's from our different webinars and seminars that we've been doing. We have a Let's Talk series I'll talk about in a couple slides here. Events like this, great ways to catch up on things. Just call our office if it's been a couple years since you've been in. Harry, Debbie, Jay Marie, myself, we're more than happy to see you guys. Oh, by the way, reminder, we have a Clifton Park office if that's convenient for you. So we're seeing a lot more traffic there, and it's good to see all your faces. Now, I'm going to be talking about real estate and trusts. And for the most part, when we do trusts, one of the biggest reasons is because someone happens to own real estate. Now, there's other factors that can go into it. There's different kinds of trusts out there. What is a trust? Well, that's an excellent question. I like to say it's a box and you put things in it. And that's pretty, there you go. I got a law degree for that. A trust is a thing that's going to hold your assets. And the rules about that box, the way you put things in, the way you get things out of it will determine the kind of trust it is. In fact, many of you that just have a will out there, right? Your biggest estate planning document is a will. More than likely, you have a trust somewhere in your will contingent on really awful things happening to your beneficiaries. Maybe we say that everything goes to our kids, and if our kids are under the age of 30, hold things in trust until 25, 30, 35, whatever ages you want. That's actually a form of trust. It's called a testamentary trust because it's in your last will and testament. The trust we're talking about right now, though, is a form of living trust, which takes two main forms, revocable or irrevocable. And here's where we get into tongue twisters and we reprogram your brains as to what these words mean. So revocable or irrevocable. Revocable means that you, the creator of the trust, can by yourself, that's the important part, you by yourself as the creator can undo the trust entirely or partially. You can take things out of the box by yourself because you are the creator, and this is a revocable trust. In irrevocable trust, well, a lot of times when we do seminars in person, I would ask, what does irrevocable mean? And most people would say things like it means that you can't control it, you can't change it, you can't undo it, right? Because it's irrevocable. Wrong, wrong, wrong. That's actually not what irrevocable means. And if you want, you could take a pen and write down what the word irrevocable means. I'm going to reprogram your brains. I'll give you a moment. Okay. Irrevocable means not revocable. That's what it means. That's what the word means. And it's important to realize that because when we say a trust is irrevocable, like a Medicaid asset protection trust is irrevocable, what we are saying is that you, the creator, by yourself, cannot remove assets from the trust. It's not revocable. Revocable means you can remove it by yourself. Irrevocable means you cannot remove it by yourself. It doesn't mean it can't be removed. Doesn't mean you can't change your trust. It doesn't mean you don't control your trust. It means you can't pull things out willy-nilly by yourself. And the reason why that becomes so important, guys, is because Medicaid cares when you can do something by yourself. If you can remove your own money from your own trust by yourself, they want those assets in the trust. In fact, they're going to say, why don't you remove money and private pay that nursing home before you ask us to do it? So what do? Well, Harry, long before I was practicing law, started doing these kinds of, started doing these trusts where, you know what, we're going to say that you and your trustee and your beneficiaries together can move money out of the trust. And that way Medicaid says, well, actually, Harry Miller, you can't remove money from your trust by yourself. Thus, if assets have been in that trust long enough, there you go, it's going to be protected. Now, that's a specific kind of irrevocable trust. There's other irrevocable trusts out there. If you use Google and you Google irrevocable trust, you're going to get some other kinds of trusts, maybe trusts that are geared towards protecting money from estate taxes, as Jean-Marie was mentioning, right? There are other kinds of irrevocable trusts with different kinds of rules. The trust we do primarily, although we do all these trusts, the Medicaid Asset Protection Trust ends up protecting money for your long-term care needs while, if it makes sense, subjecting your estate to estate taxes. Why the heck would we do that? Well, because you don't have $11.8 million, right? So we get the step up, or at least we currently get a step up in our assets on the tax basis while protecting our assets and avoiding probate and so on, which gets us to the benefits of real estate in a trust. Avoid probate. That we say that we scream it from the mountaintops as often as possible. We have probably 250 estates going on at any one time. While you would think, wow, that's great, Herzog Law Firm is doing fantastic, we'd rather have 50 because that kind of work is rather grueling. It's not pleasant for the clients, not pleasant for the family that survived them. Surrogates court, sorry, hopefully no one hears from surrogates court. They tend to make you go through hoops when common sense would mean that maybe we shouldn't. And as a result, there's time, there's expense, there's legal fees. The high end of a filing fee for a probate is $1,250. That's before any of us get involved. So it's not uncommon to have estates that cost several $1,000s. It's not uncommon to have estates that last for several years. In fact, next week, if it actually happens, we'll see if we settle. I have a trial for an estate that is for someone who passed away in 2016. It's 5 years. When we create a trust, a living trust, we like to put real estate in it because when we put your house into the trust, you no longer own your house. Now, calm down. We're not going to ask you to bring the garage door opener when you sign your trust. When you put a piece of property in a trust, it means that it's no longer going to be governed by your will because technically you don't own it. Now you'll see in the coming slides, you still pay all the bills for the property. You still have something called legal life use of the property. Still get the star exemption, all that jazz. But by putting it in a trust, when you die, you didn't own it when you died. Technically, you're trusted. Your trust was a separate entity. Thus, we don't have to probate your will to see where that house goes. The terms of the trust will dictate where your house will go. Obviously, if we're doing Medicaid trusts, it's all about protecting assets for long-term care and putting real estate in a trust, just like any other asset we put in that trust. If it's got the right rules in it, is going to protect those assets for long-term care immediately, as Kim mentioned, if it's about home care right now, 2.5 years for home care as soon as we get to, sometime next year, hopefully. 5 years down the road if it's nursing home care. Okay. Oh, wait a minute. I want to own my house. I have a mortgage, right? I'm personally liable on a mortgage. I can't put a piece of property on trust. That's not true. You can put your properties, whether or not it's encumbered by a loan, into this kind of trust. It's a grantor trust. You're not losing control. No one's selling that house. No one's kicking you out because of that legal life use. Guess who pays all the bills? You do. Taxes, insurance, everything else, maintenance, repairs. Guess who gets to live in their own house? Guess who gets to get the rent from their rental properties, right? You still do. There's no loss in tax benefits. If you have a write-off because there's a rental property, you keep that write-off, okay? Your tax returns will look the same. Let's say you sell the property one day and you sell it for a gain of $200,000. You bought it for 400 grand, you sold it for 600 grand. You're a single individual. Well, if you did that yourself, that $200,000 of profit would be tax-free based on federal tax law. Even if the trust owns your property, you will still qualify for that elimination of the first $250,000 of gain as a single individual, or 500 grand of profit as a married couple, even though it's in a quote-unquote irrevocable trust, because it's this kind of irrevocable trust. One of the big reasons I like real estate and trust, whether or not we're worried about long-term care, is because so many of you guys have camps at Sacandaga, Lake George, down in the Catskills. We have vacation properties. We have properties in Florida. We have properties in Arizona. A lot of people have property in Myrtle Beach. One of my clients this morning does. The idea is the only thing worse, first of all, the only thing worse than probate in New York is probate in New York, and then one in Florida, and then one in South Carolina, okay? But besides that, you may have this vision, right? You want not only your kids, you saw your kids grow up at the lake, you want your grandkids and great-grandkids to enjoy property. And whether or not we like it, sometimes our children fight with one another, sometimes people don't get along, sometimes it's hard to figure out who's going to pay the bills. The lake house needs a new roof. Well, I barely use the lake house. Why am I going to pay my fair share, right? I want to pay less. You could put rules on property just like you could put rules on anything else, and a great way to do it is through a trust. You could also get it done through a will, by the way, guys, but we prefer trust because that way we could avoid probate as well. So those are a number of very good reasons to put property in a trust, avoid probate, protect the asset, put rules on that, and there's no big downside to it, right? It's protecting an asset, and a lot of times it's our largest asset that we have. Now, Harry mentioned it's our 75th anniversary, and in fact, we almost forgot about it because it almost felt like 2020 didn't count as a year, but apparently it did. We are helping a number of fantastic organizations in our communities. Number one, the Alzheimer's Association. They do a series of walks in the fall, a walk to end Alzheimer's, and we are sponsors at different levels for a number of those walks. In our newsletter that'll be coming to you, we'll send you information how you may want to contribute or form your own team or participate in the walks. They're in Albany, Schenectady, Queensbury, a little further south in Catskill and lower Hudson Valley. We're going to be supporting our local senior centers like Beltrone Colony Senior Center, the Saratoga Senior Center, the Queensbury Senior Center. They do so many important things for our community. In addition to all the services that Kim was talking about with community Medicaid, these senior centers are so important to the seniors in our community. We're going to be doing a blood drive August 25th. I can't remember if we ever did one before. I'm excited about it. August 25th at our Albany office, details to follow. We may be doing one down in Ulster County as well. More information on our website coming. Couple pieces of homework here before I pass it on to Harry for our traditional question and answer period here. We're on the radio. A number of you know that. Magic 590 and 100.5 FM in the capital region, 1410 AM and 96.9 FM in the North Country. And then it's Saturday mornings, 8 to 9. On Sundays, it's replayed down in the Kingston, Ulster County area on 92.9 WBPM. Do not try to call in on Sunday. Your call will not go through because it's a recording of the Saturday show. We have a Let's Talk series that we started back up again. We had one in June. We have talks coming up in August, September, and October. You could look at our website for details, but there are topics that we don't necessarily cover in detail in our normal webinars and seminars. On 8/19, August 19th, we're talking about healthcare proxies and powers of attorney for younger clients. Incredibly important for your kids to have these basic documents in place. In September, we're talking about 12 actions to take before planning for retirement. In October, we're going to be talking about what to think about when you're selling a house, which reminds me, we have a real estate attorney who has practiced real estate for as long as many of us have practiced estate planning, and I like to think he's as good at real estate as we are at estate planning. He's very helpful with trust transactions, estate transactions in your normal buying and selling and title insurance and so on. Speaking of those webinars, last thing I'm going to say, on our website, we always have a schedule of upcoming seminars and webinars. We were just talking about when we'll go back in person, hopefully soon. But we have a whole stockpile, a library of recorded webinars that you can access on our website, herzoglaw.com, on any of these topics. They're incredibly helpful. They're easy to share, easy to review. There's nothing like sitting on a couch with a blanket and listening to Debbie or Jamery or I on a webinar. In all seriousness though, sometimes when we do webinars in person, 2 p.m., 10 a.m., it's kind of hard to get to it, right? You're going to go to some hotel conference room, or maybe you have to go to work. These are on-demand, great opportunity to listen to us and get some more factual information. Thank you so much, guys. I'm going to pass it on to Harry now. We'll take some questions if you have any.
Okay, I'm back. So we're taking questions now?
Yes.
Okay.
The first one is on Medicaid. Are these federal or state rules, and do they vary by county?
Okay. So in the community Medicaid situation, we have a question as to whether the rules that Kim talked about are federal rules, state rules, and are there variations from county to county? Well, the answer to all those things is yes, yes, yes. Medicaid is a federal program that is administered through state and county social services departments. And so the federal government has certain minimum rules that apply. For instance, the 5-year look back that Kim talked about for chronic care in a nursing home is a federal rule, all right? We have clients that said, well, I hear it's going up to 7 years. I've been hearing that for at least 7 years, I think. There's no proposal to do that. And if New York were to do that, it would need a waiver from the federal government in order to implement a 7-year look back as opposed to a 5-year look back. So But within the federal guidelines, states are free to make their own rules. So guess what? New York is probably the Rolls Royce of Medicaid benefits. You can keep more money in New York State as an individual and a married couple than practically any other state in the country. The income levels for a community spouse who's healthy and not living in the nursing home are higher than most situations. The rules are better. If you lived in South Carolina or Arizona, your asset level might only be $2,000 instead of in New York, it's $15,750. And the resource level for the healthy spouse is almost $75,000 on top of that. So it's a combination of federal and state rules. And while there are 62 counties in New York State, I think, they are all supposed to follow the rules uniformly. But they, frankly, as a practical matter, do not. For instance, where we run into this most of the time is in the area of what we call a spousal refusal. Now, a spousal refusal is like a last-minute Medicaid. It's not a Medicaid planning device. It's an emergency situation where we can transfer assets from one spouse to the other. There is no transfer penalties for interspousal transfers. Then we can apply for Medicaid even though the healthy spouse has more assets than the law allows. And they file his paper. You know, I have excess resources. Here they are. We disclose all of that stuff. But I refuse to make them available for my other spouse's nursing home here. On the basis of that, the county will put the nursing home spouse on Medicaid. All right. Now, the county has the ability to go back against the healthy spouse and seek reimbursement out of the excess resources. Well, the variation is many counties do, and there are some counties that do not. It could be because of staffing levels. It could be because of a variety of things. But so the answer to the question is, yeah, there are all sorts of variations. I guess the moral of the story here is if you are dealing with Medicaid, whether it is for home care or for a nursing home, it is critically important to all of you that you use a law firm like the Herzog law firm to handle the intricacies and ins and outs of the Medicaid process, because it is not for the uninitiated. Do not try this at home. Okay, enough said about that. Next question. No, it is not required. It is, as Debbie said, is grandfathered in under the new statute. And so you do not have to update your power of attorney. Here's some practical advice. The last time, okay, Debbie said June 13 is the drop dead date. From that point forward, you have to make the new 8-page power of attorney instead of the 14-page. Okay, so prior to that, the last amendment was like in 2009, 2010. Before that, we had a nice little 2 or 3-page form. It had gifting provisions. It had all the stuff you can do now. And that was valid too. And guess what? If you did a power of attorney in 1986, it's still valid. You may have to provide an affidavit from someone that says it's still in force and effect. It hasn't been revoked or anything. But otherwise, you know, it's good to go. Here's what's happened. In 2009, 2010, it's been 11 or 12 years since the new statute went into effect. And if I take a power of attorney with a client to a bank that was done in 1995 or 2007, and it's the old 2-page form, you know, guess what? The branch manager at the bank was in elementary school when the power of attorney, the 2-page, they don't know what the 2-page power of attorney says. This is, blah, 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 blah. You can't use this. I said, well, it is perfectly valid. I'll give you a legal opinion from my lawyer. Well, then you know what happens? They're going to have the bank attorney's going to want to look at it. You know, it's going to cause delay. It's going to cause expense and all those other good things. So my advice to all of you is come on in and get a new power of attorney, even though you don't need one, because going forward, we're going to have the same problem in about 5 or 6 years. The people at the bank are not going to understand or recognize the old 14-page, you know, gargantuan one. So let's get the new one in place. We're here to help you, and you know, that's it. Oh, I'm sorry. Yes.
I have a house in New York and a house in Florida. Do I need to deed both to the trust?
Yes, I have a house in New York and I have a house in Florida. Do I need to put both of them in a trust? Yes, you do. Yes, you do. Because if you don't, you're going to wind up probating the house. Say, well, it's already in joint names with my husband or my wife. Yeah, okay, great. Well, that's fine. So when the first person dies, you don't have to probate the will. It automatically passes to the second person. But guess what? When the second person dies, it's not in joint names with anybody anymore, is it? Okay. Now, putting your kids on the deed, maybe okay, maybe not such a great thing. If they have matrimonial problems, if they have credit problems, if they have unpaid taxes, you put your kid's name on the deed, it potentially exposes your properties to their creditors. That's a big no-no we want to try to avoid. So what do we want to do? We want to set up a trust to put the two properties. And you don't need a separate trust for each property. I, for instance, own property in 2 states. I own property in New York, and I also own property in North Carolina. So my wife and I have the same problem that you all do who have condos in Florida or timeshares. And timeshares are deeded. You know what? A timeshare, it's a deed. So it could become a real challenge in estate administration situations. And so we put both the properties in one trust. We don't have to pay the lawyer to do 2 trusts. We only need one trust. Our trust is a revocable trust. It doesn't even have to file tax returns. So there's ongoing no maintenance about it. If we change who wants to get the properties after we're dead, we can do that anytime we want to because it's a revocable trust. We can change it, amend it, do anything we want to it, and we don't need anyone's consent other than the 2 of us. So it's kind of a no-brainer from a planning standpoint. And if you're looking at an asset protection trust, which, as David said, is a kind of irrevocable trust that can be revoked under certain circumstances that we build into your trust document, then not only can you avoid probate in 2 states, but you can also protect your real estate assets from a subsequent nursing home placement. It's really a very practical, beneficial, legal transaction. Thank you.
Okay, another question. New York powers of attorney valid in Florida.
Are New York powers of attorney valid in Florida? I believe so, yes. I believe they are. New York, for instance, has a statute that says if you have an out-of-state power of attorney that was valid in the state when it was executed, that it is valid in New York. That sounds pretty easy, doesn't it? Well, the same is probably true. I'm sure Florida has a statute that says your New York power of attorney is valid in Florida if it was validly signed in New York. You know, it's like with other legal things, it sounds simple, but it's not. You know, for every rule, there's a dozen exceptions. So, you know, here's what happens. Again, it's a question of timing, delay, and expense. So I take my New York power of attorney down to Florida, and I want to use it to do a banking transaction or to sign a deed. And New York isn't so different because there's so many people from New York that live in Florida in the winter that if people in Florida, lawyers in Florida, banks are very commonly know what a New York power of attorney looks like, although they probably haven't seen the new form yet very much. So here's what happens. And I've had this happen to me. I've had a lawyer, you know, a client who has moved to Arkansas and has taken their New York power of attorney to an Arkansas bank and to use it for a banking transaction. So guess what? The bank in Arkansas, the lady who's the branch manager, she tells the people, well, I don't know if it's valid or not. I need an opinion from your New York lawyer that says it's valid, it was legally executed. All these things take time, they cost money, and they create, you know, if you're moved to Florida, here's what I do. My Florida clients who also live in New York, here's what I recommend to them. Have a New York and a Florida power of attorney. Have a New York and a Florida healthcare proxy. Because guess what? There are 50 different power of attorney and healthcare proxy forms. Each state has its own form, and they're all different from each other forms. So if you spend 6 months a year in Florida, get your Florida lawyer to do a Florida power of attorney. I have a North Carolina power of attorney and a North Carolina healthcare proxy for me and my wife. Because if we get sick down in North Carolina, I don't want to get delay in doing banking transactions or healthcare decisions because I need the bank or the hospital needs to have their lawyer review these documents. So, there's no reason you can't have 2 or 3 different powers of attorney. So it's just, it's practical. As David said early on, a lot of this stuff is just common sense, practical answers to questions. And that's what we try to do at the Herzog Law Firm. We try to speak in language that you understand. We don't speak lawyer in this firm. And we're problem solvers. What can I say?
Okay, our next question is the power of attorney is 5,000 gifting. Is it once a year or is it aggregate? This is more of a comment that Social Security does not accept power of attorney.
So in the power of attorney form we were talking about, the new form with the gifting provisions, which are now incorporated into the modification section rather than a separately executed and witnessed gifting rider, is the $5,000 gifting limit, which used to be $500 annual. Yes, it's an annual gifting exclusion. So you person who does not have the gifting and transaction and transfer provisions incorporated into the modification section, that agent is limited to making $5,000 a year of total gifts to anyone. That includes charitable organizations, your church, any kind of gifts to your kids, those things are all gifts to your spouse, which is, as Debbie said, are going to far exceed, if we have to transfer a piece of real estate, it's going to far exceed the $5,000 limit. And then the second part of the question was
that
Social Security does not accept state powers of attorney forms. And I think that's correct, right? Yeah. So you have to, this is also true of the Internal Revenue Service, all right? If you appoint someone as an agent through the, to handle, let's say you appoint your accountant power of attorney to handle your tax returns. When we get a tax ID number from client, they appoint us as an attorney to handle matters relating to their Medicaid trust. The same thing is true of Social Security. Social Security will not accept a power of attorney from New York or any other state. They have their own, I believe they don't accept one, period, right? They have their own form, just like the state tax department does and the IRS does. So if you anticipate a need to act on someone's behalf in that regard, you need to get the Social Security power of attorney form, have it filled out, signed, notarized, keep it in a drawer somewhere in case you need to use it down the road. You can also be appointed something I think is called a representative payee for someone who is incapacitated or may not fully understand the letters. I don't think anybody understands the letters that come from Social Security, if you've ever gotten any of them. But I mean, I have this problem ever since I went on Social Security. Every year they calculate my benefit incorrectly. And then around October or November, toward the end of the year, I get a letter that says, oh, we've calculated your benefit incorrectly. And so next month we're going to deposit, $600 into your account because we underpaid you for the last 12 months. So these people, just because they're governmental agencies, don't always have all the correct answers. But and also the thing is, if you're in the new power of attorney form that Debbie was talking about, if you sign a new power of attorney and you revoke your prior powers of attorney, you're not revoking the governmental powers of attorney, because the definition of power of attorney in the new statute excludes things like IRS, New York State, Social Security, federal government powers of attorney that you have to give to the government in order to transact business with them. So you'd have to worry about canceling them inadvertently from signing the new form.
Okay, so one more question.
Well, we got one more question, and then we're going to let you go. So what are some of the steps involved in setting up a real estate trust? Well, want me to answer this, or David, huh? David, you want to answer this one? Huh? Yeah. Okay. All right. So the real estate, so the real estate trust it's just like any other, it's basically any other trust, because it can not only hold your real estate. A revocable trust is the simplest kind of trust that exists, because you are the person creating the trust. You are the settlor or the grantor. You are the trustee of the trust, unless you want someone else to be a trustee with you. And during your lifetime, you're the sole beneficiary of the trust. So, in fact, for many years, until about 20 years ago, New York didn't recognize this kind of a trust as a legal trust in this state. You had to have a non-grantor co-trustee in order to be a legal revocable trust in New York. So people say, well, the heck with that. I don't want to do that. I want my kids to know my money. I don't want to have my kids sign anything when I set up a trust. So Florida had these kind of trusts for decades, since the end of World War II. And so a lot of New York people moved to Florida and set up these things with Florida lawyers. And then guess what? They started to move their New York money and assets and stocks into the banks in Florida and investment firms in Florida. And the New York financial community went berserk. And so they successfully lobbied the legislature that year, all right, to poof, all of a sudden, magically, a self-settled revocable trust became a valid legal trust in New York. It had nothing to do with the law. It had to do with money and the movement of money out of the state, which got Wall Street all upset. But the fact of the matter is, it's a simple trust to set up. And you can put real estate in it, whether it's in New York or Florida, Arizona, or Timbuktu. I've actually had a client who had a revocable trust in New York who owned like 6 or 8 timeshares in Puerto Rico. Well, we got his lawyer in Puerto Rico to deed his timeshares to his New York revocable trust, because I don't want to probate his will in Puerto Rico when he passes away either. So it's a great thing for everybody. And if you couple it with the Medicaid Asset Protection Trust, the only difference there is you're going to have you can't be the trustee, not because of trust law. You'll still going to be the grantor. You're going to be the sole beneficiary during your lifetime, but you have to have somebody else, like one of your kids or your brother or sister, be the trustee of the trust. That's a Medicaid rule, because if you're the trustee of your own trust under Medicaid, those assets in the trust are going to be considered available resources that have to be spent down on your Medicaid planning. So again, not a trust rule, not a New York legal rule. It's a Medicaid regulatory rule that requires you to have an independent trustee. But we build into our trust enough bells and whistles so that you have some indirect decision-making control over the trustee. So once again, thank you all for taking the time this morning to join us, and wish you a great day, and keep in touch and stay tuned for additional events coming down between now and the end of the year.